Okay, welcome everybody to this very popular webinar on estate planning. I'd like to thank Lorraine Coyle for offering to do this for us. Just to introduce Lorraine, she lives and works in Manhattan and Ancramdale, and she concentrates in trusts and estates, guardianship, and real estate. She has been the director of the trusts and estates and elder law sections of the New York State Bar Association. So we're very lucky to have her with us today to tell us all about these important topics. So just a few ground rules, because there are so many people, I would like to ask everybody to please mute themselves unless they're talking. Lorraine is going to present different topics and stop periodically to ask for questions. And if you have questions, as you know, as she's talking and you think of questions, if you could please put them in the chat box, and then when we stop, I'll share those with her and she can answer them for us. So I will now turn it over to Lorraine.
Okay, thank you. And good evening. And thank you to Roseanne and the other libraries who are participating in this. This is really terrific. And thank you, Tamara Gaskell, who set this up. I'm pretty facile with the computer, but this starting Zoom is a new world for all of us. And it seems to be working pretty well. So a lot of speakers. Oh, let me introduce my husband, because in fairness, I told him he has to sit in the back and not talk, but he's in the back. His name is Oliver Coyle, and he's also an attorney, although he doesn't do trusts and estates. So a lot of speakers open with a joke, and you will find out that I'm not really a very funny person. So, but I do have two statements that are going to make you really happy. The first statement is your son-in-law. You never liked him, he never liked you, and you don't have to give him anything. And that's true for your daughter-in-law as well. And the other thing is, right now, as you know, this seminar is free. That's terrific. But about half of you, maybe even more than half, a little bit less than half, are going to walk away from this seminar with money. Now, how is that possible? I can't hand it to you through the window, can I? But I'm going to put a thing up called resources right now. And if you'll see on the resources, there are, does everybody see it?
No, it's not up. No.
Okay, Tamara, can you get that up then? Because maybe
it looks like you're not sharing your screen. You have to go to share content.
Okay, let me go back to that.
There's a green box at the bottom.
Yeah, thank you. So I'm now, where am I now? Oh my goodness, where am I?
Let's see. I can put it up in just a second.
Okay, but I'm sort of, I've disappeared from myself, which is not a good sign.
We see you.
You see me, but I don't see you, and I want to see.
That means you're probably opened up one. Okay.
Share screen.
And Tamara, are you going to send out the what you're going to be sharing right now as well?
Yes, I'll send this out tomorrow. But here.
Thank you so much.
Okay. So if you see it has missing money. What you're going to find after you get off this seminar, you go to the websites, the ones that I mentioned. In New York State, most of us are New York State residents have probably lived here most of our lives. So you go into the Office of State Controller, put in your name, last name, maybe first name, and you'll find that about half of you have money there. I can't tell you how much it is, but I can tell you it's there. 1/3 to a little bit more than 1/2 of the people on this seminar will find money. There are also other ways, because we didn't always live just in New York. We've lived in Connecticut, we've lived in California, we've lived in Montana. There are other places. Every state has a website for unclaimed funds. So go to the websites of the various states that you've lived in, put your name in, and you're going to be shocked. Last night, I wanted to test these websites to make sure they're still good URLs. And I put my brother's number, my brother who died 3 years ago, and my mother who died almost 30 years ago, and both of them have money. And nobody has claimed that in all these years. So there's also these missing savings bonds. You know, when you were kids, you got these $50 savings bonds or $25 savings bonds, and who knows where they are. But there's a treasurydirect.gov that you can search for your missing savings bonds. And it's something really to look at, because really the money is there for you. Now let's go over to what we're talking about. We're going to divide the discussion into about 7 discrete areas. And I'm going to take the low hanging fruit first. And that means the easiest one, and that's the healthcare proxy. Now, I would assume a fair number of you already have healthcare proxies, but if you don't, I really encourage you to do them. They're very simple. You sign them in front of two witnesses, and you appoint somebody who's going to honor what you want done. So, for example, in my marriage, my husband is the kind of person who feels where there's life, there's hope. So he is not a pull the plug kind of guy. I, on the other hand, feel, yes, where there's life, there's hope, but I don't want to be in the end suffering, and I don't want to be lingering. So I, on the other hand, want somebody who's going to be willing to pull the plug. So the irony is I'm married to somebody who won't pull the plug, and he's married to somebody who will pull the plug. So I've actually provided in my own healthcare proxy that my husband is not the healthcare proxy. He's not surprised at this. He knows about this, but he has me as his healthcare proxy, and he knows I will honor his wishes. So on the share screen, maybe Tamara, if you can put that up, since I wasn't so good with that before, is a sample healthcare proxy. You don't need to use this one. You can go in the New York State website, the Department of Health website, and it's free. There's an amazing amount of stuff that's free. Well, we all know that, but you can get this and you can download it. You just have to have two people initial it. So I did one with my name. So here it is, Lorraine Coyle, hereby appoint, I would say my sister, Barbara Morgan, residing at, and her telephone number. And then on the second one, let's say Barbara's not around, I want to appoint somebody else. I appoint an alternate. Now, if you look on number 3, the proxy remains in effect unless you revoke it. I have never had somebody, well, maybe once, revoke the healthcare proxy. In number 4, this is a little bit dicey because a lot of people want to put in some of their wishes. Oh, I don't want to be kept alive if there's no hope of recovery. And that's a pretty amorphous statement, because what does hope of recovery mean? I recommend that everybody not fill in 4 and make sure that your healthcare agent, will honor your wishes. In 5, this is another one that's very important. The law says food and water cannot be withdrawn unless you have authorized it. So in 5, if you want to authorize the withdrawal of food and water, you need to sign line 5. Line 6, this is where you can donate organs. You can do it, you can limit the organs, you can say they can take it all, whatever you want to do. And I would say that in my practice, about 60 to 70% of people do make an anatomical gift. It's not required. And in 7, if you don't want to make an anatomical gift, and mostly the people who say they don't want to are older, maybe they're in the 85, 90, 95, and they say, oh, nobody wants my organs. Well, in fact, that's not true. They're willing and happy to take your organs up to about age 99. And even if you don't want to donate organs, you can donate your whole body to science. And you can do that by signing number 6. And then you sign number 8. You put your address, the date, and then the witnesses sign. And ideally, they sign legibly. It's not a terrible thing if they don't sign legibly, but it's really a good thing. And then you put your address right under that. It does need 2 witnesses, and neither of the witnesses can be someone who you have appointed as your agent. So let's say you want your son and daughter as your agent. They cannot be the witnesses to that. That will invalidate this healthcare proxy. So just be careful about that. But this is really a good document. You can either use this and white out my name, or we can send you one which doesn't have my name on it, or you just download it from the Department of Health. Really, really important to do. With the power, so let's see if there are any questions on this healthcare proxy before we go on to the next item. Tamara, do you see any questions? Anybody raising their hand? Nope. So shall we go on? Okay. So the next thing is a power of attorney. Now, the power of attorney is, everybody says to me, I want a durable power of attorney. Well, in all the years I'm doing this, and I've been doing this for almost 40 years, and I've done thousands of powers of attorney. Every single one, but maybe 5, have been durable. It used to be historically that the power of attorney ended if you became disabled. But that's really what a power of attorney is for, isn't it? You want it so that if you are disabled, that somebody can sign checks for you, can pay your bills, can make the mortgage payments. You want somebody to step into your place financially. So all powers of attorney now are durable powers of attorney, unless you say otherwise. It does actually say on the power of attorney, durable power of attorney. Now, who should be your power of attorney? Does anybody have an idea of who should that be? Anybody? Nobody has an idea of who the power of attorney should be? All right.
It
Well,
shouldn't-
Can I say something?
sure, sure.
I have a power of attorney. It's my brother.
Mhm.
A trust was because my father just passed away and his estate was divided. And because he knew that I am not knowledgeable financially, and my brother is an attorney, he put in his will that he wanted that trust, and my brother was going to be the trustee. So that's really why I'm here, is I want to hear more about this.
Sure. We're conflating powers of attorney and trusts. A power of attorney is not a trust. It's a document that you entrust to somebody. That's important, but it is not actually a trust. A trust is a document where you essentially say, here's my money, I'm giving it to you to hold for the benefit of somebody else. But the power of attorney is one where you actually stand in the stead of the person who's giving the power of attorney. So for me, my power of attorney is given to my husband. I don't have a trust because I'm not a big proponent of trust, as you'll see later on in the discussion. But the power of attorney is somebody who you should trust. Now, should it be your attorney? And the answer is no. You don't have to bring your attorney in for any reason unless, as in this case, the lady's brother is an attorney, and that makes some sense. But don't use your attorney for things that you don't need your attorney for, because your attorney is going to charge and your family members are not going to charge. So why not just have somebody who really is near and dear to you, but who you trust? And that is really key, because I always say to the people, I say, do you trust your son? And 99% of the time people say yes. But there's that 1% of the time that people say no. And I have to say to them, you know what, then that son is not a good person to be your power of attorney. And it's hard for the people to deal with that. But you know your kids, you know your brothers, you know your sisters, and you know your husband, and you know how trustworthy, and your wife, and you know how trustworthy they are. And they're not all trustworthy. So you've got to be really careful when you're doing the power of attorney, because once you give that power of attorney away, it's out there and that person can use it. So what I say to everybody when I do a power of attorney, I say, don't give it away. I actually put a piece of paper on the top of the power of attorney and it says, this is a very important financial document. Do not give it away until needed. So now your next question obviously is, well, how are they going to get it if they need the power of attorney? Trust me, they always get it. They'll get into your apartment, they'll find the power of attorney, and they'll have it. I always scan all powers. So on occasion, not very often, but on occasion, I've had somebody call me up and say, my sister's in the hospital, I need that power of attorney. What I have done is I've gone to the hospital, I've checked that in fact, the person is really in bad shape, and I have released the power of attorney. But that has really happened maybe once, maybe twice. Now, as part of the power of attorney, there is what's called the statutory gifts rider. This is really important. A lot of the people on this, when you go to an estate planning seminar, you generally are people of means. People without money generally, but not always, come to estate planning seminars. So you might say, well, gee, if I become disabled and if I have to go into a nursing home, am I going to lose all your money? The answer is yes, unless you prepare. And you're here because you're going to prepare. And one of the ways that you prepare for that is to do a power of attorney that will allow us, when I say us, whoever is your power of attorney, who is ever your agent, to make transfers to protect assets so all the money doesn't go to the nursing home or all the money doesn't go to home care. Now, all of you have heard the term, oh, there's a 5-year look back period. Well, yes, there's a 5-year look back period up to a point, because there are ways to get legally, there are ways of getting around that 5-year look back period. But if you sign this power of attorney, which is now about 11 or 12 pages. It's a little crazy. When I first started practicing law, it was 2 pages and so simple, so nice. And now it's literally 11 pages, single spaced. Happily, and you'll see on that resource list, the legislature has realized that this has gotten out of hand, and there's a new power of attorney coming down the pike on June 13th. We don't have it fully set yet, so I don't want to share that with you until it is. So if you want to wait until June 13th, till the new power of attorney comes in, that's great. But if you feel you need the power of attorney now, it's going to be grandfathered in. So any powers that you have now, you can still use after June 13th. No worries whatsoever. What's the advantage of having this power of attorney and healthcare proxy? Who cares? Well, if you're going to be healthy till the day you die, you don't need them. You can do everything yourself. The power of attorney and the healthcare proxy only come into play when you're disabled. If you can make medical decisions yourself, you make them. If you can make financial decisions yourself, you make them. But let's say you've taken a trip to Europe and you get stuck and some bill has to be paid. If you've given the power of attorney to somebody, they can make that payment. But for the most part, it really has to do with a disability. But the big benefit of this is that by preparing today with a power of attorney and a healthcare proxy, you can avoid guardianship. Now, what is guardianship? Guardianship, and Have a plug to my husband on this one. Guardianship is a legal term that means if you haven't prepared financially or medically for yourself and you become disabled and you have assets in your own name that somebody has to access to pay bills or to pay the doctor or pay the hospital or pay the nursing home, if you haven't done that, you have to go to court and have a guardianship appointed for you. And you're not the one who goes to court. Obviously, it would be a family member or a friend, occasionally an attorney, to say, look, Mary Smith needs this power, needs a guardianship. And let me tell you, a guardianship is not cheap, to say the least, and it's very intrusive. And the court is always looking over the shoulder of the guardians from now until the guardianship ends, and it usually doesn't end until you die. When I say not cheap, a cheap guardianship would be $5,000, and a non-cheap guardianship can go up to $200,000 with litigation. So I strongly, strongly encourage you to do the healthcare proxy and the power of attorney, because if they are in place, the courts say, wait a second, this lady, this man has prepared for himself, herself, and we don't need to bring the court in because she's already made preparation for that. So as you can see, I can tell you it's really important to have these powers of attorney and healthcare proxy in place. And if you want, what you really have to do is include that statutory gifts rider, because that will allow you, even as you're about to go into the nursing home tomorrow, we can still save money. I'm sorry?
Home back.
We can still save money because all your money does not have to be dissipated when you go into the nursing home. You have to know how to do it. So you need to go to an attorney who can do it for you, or you read up really, really hard. And in fact, on the resource list at the bottom, I put the URL, the Uniform Resource Locator, we call the address. I put that in so that you can find out if you want to read up on Medicaid yourself, read up on it. It's a pretty complicated subject, I will tell you, but it's worth your having that knowledge before you go to an attorney even to say, hey, wait a second, what about this? Or what about this? So read up on it and then go to an attorney. It would be really, really difficult to do a Medicaid application on your own. Now, if people are in a nursing home and they have no assets, the nursing home does it itself, not a problem. But let's say you have assets and you're going to do one of these legal methods of transferring assets, and you're going to file for a Medicaid application so that you save some of your estate. You can't really save it all, but you can save some of the estate. That could cost anywhere between $15,000 and $20,000. So once again, if you have all these things in place ahead of time and you know what you're doing, you can save a lot of money. Now, let's talk about the power of attorney and see if there are any questions with the power of attorney, because I'm doing all the talking.
Yeah.
And
It looks like Nancy Kaplan has a question.
hi, Nancy.
Yeah, hi. First of all, I wondered what the statutory gift rider was. What did you say that was?
Oh, okay, I'm glad you said that. The law says that a power of attorney cannot be used to add to your own finances. So let's say, in my case, I have a husband and a daughter. I give them my power of attorney. They can't give money to themselves unless I have authorized it. And the
Got it.
way I authorize it is through signing the statutory gifts rider. We call it a sugar or statutory gifts rider. It's a separate document. It's appended to the main document. So the main document now is about 6 pages. The statutory gifts rider is about 5 pages. And basically it says, I'm okay with giving this money to my agents, even though I know that aggrandizes them financially. Now, this goes back to a case years ago. It was a Salvation Army case. The nephew, right before the person died, the nephew used the power of attorney to make gifts to himself, and the Salvation Army was the beneficiary of the estate, the primary beneficiary of the estate. Well, when the Salvation Army found out that all these gifts had been made, Salvation Army goes into court and says, wait a second, nephew, you had no right to do that. Nephew pulls out his power of attorney and says, here's my power of attorney. And the court said, no. This power of attorney does not allow for gifts more than $500. You can't do that for your own benefit. It has to be for the benefit of the person who's signing the power of attorney, the primary one, what they call the principal. It's a fiction, because what we're doing by signing the statutory gifts rider, Nancy, is we're saying, here, you're my agent, take my money, because
Right.
I don't want all the money going to the nursing home. And it's a
Right.
really important document.
Wow.
I'm sorry?
That's a lot. I mean, I worked in nursing homes. That's a lot. You could take it all then, and the nursing home can't get the money. Is that it?
No, you can't take it all. The law doesn't allow taking it all, but let's say you came to me tomorrow and said, you know what, Lorraine, I want to do something with this. I'm going into a nursing home tomorrow and I need to protect assets. I could protect about 40 to 50% of your assets. I
Okay,
can't protect all of them, but I can protect a good deal of them.
got it.
Now, you can do some preparing in advance. If, for example, you wanted to transfer assets today, completely out of the picture, to a trust, an irrevocable, what's called a MAP, a Medicaid Asset Protection Trust,
Right.
you can protect assets, and the nursing home also may not get much. But really, do you want to do that? Do you want to really make yourself absent any money, bereft of all funds? I'm not, there are attorneys who push these Medicaid Asset Protection Trusts. I don't. I think for the most part, people want to be independent. They want to keep their money. And you know what? If the kids don't get all of it, they get most of it or a lot of it. That's okay with me. So I don't push these Medicaid Asset Protection Trusts. I know a lot of people do. But
Right.
and remember, for the most part, the people on this screen, you're not going to ever need a nursing home. Only, I think 15 to 20% of people wind up in a nursing home. So you've got a really good chance of never going to nursing home. So do you really want to give away all your money? Well, wink, wink. You say, oh yeah, but my daughter will give it back to me if I need it. Well, wink, wink. Your daughter dies, and wink, wink. Son-in-law, remember, he never liked you and you never liked him. He says, oh, well, gee, I don't think so, Mom. I know I liked you a lot, but you know what? This money now is really, you gave it to us, and it's really, I need it for myself. You never get it back. So you've got to know that when you transfer these assets out, they're gone. Now, again, wink, wink, it is true that some people will give it back. I don't want to say that everybody won't, but you want to protect yourself too. You want to protect your kids. You want to protect your husband. You want to protect grandchildren, maybe siblings. Nobody ever really tries to protect charities. I can tell you that. That's never an issue. So there's always something that can be done. And that's the thing I want everybody to take away today. From the point of view of Medicaid planning, there's always something that can be done. You go into a nursing home tomorrow, you're in a nursing home for 6 months, we can still protect some assets. You just have to be, one, willing to do it, and you have to have the competency to do it, or You have to have signed this power of attorney with the statutory gifts rider that allows your agent to make those financial decisions and transfers, financial money transfers. Just know it can be done. I cannot tell you the number of people who have come to me and said, oh, you know what? I say, well, would you like to do some Medicaid planning? And well, no, I know the nursing home. I say, because my sister was in a nursing home and she was there for 10 years and we had to spend all her money on the nursing home. Oh, breaks my heart. Because if they had come to me or somebody like me 10 years ago, or 8 years ago, or 5 years ago, I could have saved a lot of money for them. And it's all legal. Now, you might say, is it ethical? You know what? That's a decision I'm not prepared to make for you. If somebody has millions and millions of dollars, do I really think it's right that the government pays for nursing homes? Probably not. But it is legal. And ethically, attorneys have to tell you what you can legally do. The ethics of it, that's up to you. Some people will say, no, I don't care. I'm going to pay all my money. People who are single very often will say to me, no, I don't want to protect any money. I want the money for me. They might have siblings who they like or nieces and nephews who they like, but they have a mindset that the money is going to be for them. The reality is that most everybody who's in a nursing home is on Medicaid. Most everybody. It's not as though if you're in a nursing home, you're going to be treated differently if you're on Medicaid or not on Medicaid. And I think, Nancy, you said you worked at a nursing home, and
I
maybe
did.
you can confirm this.
Yes, no, that's true. They're all treated the same.
Yeah.
Basically. And
So-
basically, most people are on Medicaid.
Yeah. So see, I have a plant, and Nancy is my plant. So if you're single and you want to protect assets to family or friends, you can still do it. So let's talk about now.
Oh, Lorraine, there's a couple other questions.
Oh, sure, good.
We have a question about if once you assign a power of attorney, can you change your mind?
Yes, and that's why I say I put on a document, big 8.5 by 11, power of attorney, do not give it away. Because if you've never given it away, you never have to ask for it back. Sometimes relationships change. So let's say you have a son. I always pick on the sons because I have a daughter, I guess, so I can pick on a son. Let's say this, you give your power of attorney to your son, and it's 3 years later, and you actually have physically given it to him. And it's 3 years later, and you have a fight with your son, and it's not going to be fixed very quickly. So you really want that power of attorney back. Well, if you've never given it away, you never have to ask for it back, because that could be the straw that breaks the camel's back. You say to Johnny, you know, I gave you that power of attorney 3 years ago, but we just had this fight. I want it back. Oh, that's not going to be a good situation. But if you've never given it away to Johnny, you never have to worry about it being taken back. Now, there is a legal way of doing it. Let's say and it's really farcical because you'll find out in a moment. Let's say you give this power of attorney to Johnny, but you don't want to tell him that you've given it to him. You can actually file a revocation in court. I revoke Johnny's power of attorney. And supposedly the whole world now is going to know that you've revoked this power of attorney. It doesn't happen that way. I mean, it just doesn't. I've never, ever once looked at a power of attorney in court or seen a power of attorney in court. I had one filed, never, ever, ever. So the best course of action is don't give it away. You don't have to ask for it back. Then you just tear it up. You don't want that power of attorney to be active, tear it up. Now, in my case, as I say, I scan everything in. So if a client ever needs it, and that happens a few times a year, they might need it. They'll call me up. I need my power of attorney. I'm about to go into the nursing home, and they want to show that Johnny has my power of attorney. Then I just get a copy over to the client. So don't give it away. Keep it in your hot little hands. Where should you keep it? Some people say, oh, I'll just put it in my safe deposit box. Well, no, because your safe deposit box is locked and your kids don't have the keys. And the only way they can get the keys is because of the power of attorney that's in the box that they can't access through the power of attorney. So it's a renvoi, it doesn't work. What you really need to do is to keep it in your nightstand. Now, by all means, tell your children that it exists. Because if they don't know it exists, it doesn't exist. So tell them it exists, but what you do is you say to them, well, one of the kids, or maybe your only child, will say, you know, Mom, why don't you just send it to me? You know what? The attorney said I'm supposed to keep it. And you know, when I tell a client that they don't have to give it away, I can see their shoulders. Oh, good, I don't have to give it away. Because nobody wants to give away their power of attorney. Nobody. You want your own independence. So you keep your power of attorney to yourself. So I hope that answered your question fully. Does anybody else? There were a few questions. Yeah.
So there was a follow-up question by
Sure.
what do you mean by give it away? And I gather you mean by physically give them the document.
That's correct.
And
That's correct.
there's one other question, and that
Sure.
is, once the new power of attorney form is available, would you recommend that clients that have existing ones fill out the new form?
The answer is this is a money generator for attorneys. I would recommend, it's not really necessary. A lot depends upon how old your power of attorney is. If it's recent, I would say just leave it alone. If you have an old power of attorney, banks are always reluctant to take old powers of attorney anyway. And by old, I mean anywhere between 5 and 10 years and more old. They like to see something recent. I, as an attorney, when I have to see somebody's power of attorney, I want to see something recent too. If it's going to cost you very much, I would say forget it. There will be on the New York State Bar Association website, and I think, did I put that on the resource list? If I didn't, I will give it to you right now. There is going to be a new power of attorney on the New York State Bar Association, New York State Bar Association.org, NY Bar A New York State, NYSBA.org, and it will be free and you can download it. Now, I don't know, because we haven't seen the new power of attorney yet, so I don't know how it's going to incorporate the statutory gifts rider that's really so important and that's really key to saving for Medicaid purposes. But right now there is the present power of attorney is on the New York State Bar Association website. You can download it, and if it has the statutory gifts rider on it, which I believe it does, you're good to go. So the answer is, the bottom line is, if you're doing it as part of new planning, or you want to do a new will, a new trust or whatever, yeah, do the new one and maybe even wait till June 13th. But if you've done something recently, I would say it's going to be grandfathered in. It's going to be okay. I would not spend the money on it. No. Bottom line, don't spend the money. Tamara, do we have any
Okay,
more?
I don't see any more questions.
Okay.
Yeah, I have a question if I
Sure.
may. Sorry. Are those changes just for New York State?
Good question, because every state has its own power of attorney. Now, a lot of states give reciprocity because under the Constitution, where the states are supposed to give reciprocity to all other states' judgments, and they very often give reciprocity to statutes as well. But if, for example, you have a summer house in Florida, I guess you don't have a summer house in Florida. I guess you have a winter house in Florida. If you have a winter house in Florida, you have a house up here in Ankrum, it might be a good idea, although I know Florida does have reciprocity, to do a power of attorney in Florida as well, so that there's no issue about it being honored. And all these powers of attorney, all these documents are online. The only reason to have an attorney prepare it is if, like, belt and suspenders, to make sure it's right. But if the power of attorney has the statutory gifts rider for New York, use it. The ones that we use, attorneys use, have so much extra language, but a lot of it really isn't necessary, but we've gotten used to just adding. So if you have another state, I would say better way to have it in another state. By the way, if you're transferring real estate, very often the state will need its own power of attorney. So if you have a house in Florida, and I use Florida because there are so many, snowbirds, get a Florida power of attorney. It makes sense. It will save a lot of time and money. Oh, we are good to go?
There was just one follow-up question
Sure,
on somebody who asked, they still don't understand the importance of the statutory gift rider.
Okay, good. Okay. So historically, we had a 2-page power of attorney, very easy power of attorney. Then the Salvation Army case came up a number of years ago, where the power of attorney, the Court of Appeal said, a power of attorney cannot be used to give gifts to your agent. So in my case, my power of attorney could not be given, my husband or my daughter could not use the power of attorney to make gifts to themselves. But let's say I'm going into a nursing home tomorrow and I want to do some Medicaid planning, some fancy last minute Medicaid planning, and it's really not that fancy, but let's call it fancy, Medicaid planning. If I don't have a power of attorney that permits gift giving beyond $500, $10,000, then the courts say that power of attorney cannot be used to make those transfers for Medicaid purposes. So when I'm going to this nursing home tomorrow, my husband flashes his power of attorney that says, aha, I have a statutory gifts rider that allows me to transfer my wife's money to me, and that is allowed. And the reason the benefit is because between spouses, everything that gets transferred, there is no penalty period for that. I was going to go into this at the end, but this is a good time for it. So what does that mean? So spouse to spouse, I transfer all my money to my husband. Next week, he files a Medicaid application because I no longer have any money. And you might say, why? This doesn't make any sense. Well, maybe it doesn't make any sense, but them's the law. So if he has this power of attorney with a statutory gifts rider, he can use that power of attorney to transfer all the money to himself. And then I go on Medicaid right away. And I mean right away within a month. Now, the Department of Social Services of the different counties have a right to sue him for some of the money, but they don't get it all back. They get only part of it back. So the statutory gifts rider is a Medicaid planning piece. Now, why is this confusing? Medicaid is an extremely confusing statute. If you do not do Medicaid planning properly, you could wind up having to pay for nursing home care for many years. So this is where I would encourage you to go to an attorney who really does know what to do with this. But basically, the statutory gifts rider overrides the Court of Appeals decision in the Salvation Army case to allow your agent to make gifts to himself or herself to protect assets against Medicaid, against nursing home care, and against home care. Now, if that isn't clear now, and I may very well not be, just understand that it is like an insurance policy that you paid for. And if you need to go into nursing home or you need home care, you have that protection in the statutory gifts rider.
Got it.
Okay, and it looks like Nancy Kaplan has another question.
I have another question. I have all these documents in our house, but the originals are with our attorney. So if tomorrow our sons had to take the copies, are they valid, or do you need the original?
The healthcare proxy can be duplicated and you can make 100 copies of it.
Okay.
The power of attorney can be duplicated, 100
Okay.
copies, not the will. The will
No, that's
is
okay.
the original, and it's one original. You never sign two originals when you sign them. No.
Got it. Okay.
Okay. So now the
Sorry,
big,
we have one more.
sure, go ahead.
Well, we'll move on. But this one is, can I keep a statutory gift rider as you recommend with a power of attorney? I already signed a power of attorney for my brother to invest my inherited assets.
You will need to do a new power of attorney with the statutory gifts rider because they have to be signed at the same time. And they get appended, so they get stapled together. This 11-page document gets stapled together, and that's your power of attorney with the statutory gifts rider. So you do have to redo that. Your attorney probably should have suggested that. I do know there are a lot of attorneys who are not familiar with the statutory gifts rider, and I'm kind of surprised by that because I'm not picking on your attorney, but that should have been offered to you as de rigueur, that this is just normal stuff. I mean, there's almost nobody who doesn't do a statutory gifts rider. Anybody else, or shall we move on? Move on?
I don't
Move
see
on?
anything else.
Okay, all right, so now what we sort of started to come for, and a will. And the question is, do you need a will? Maybe let's ask the question, does everybody need a will? Yes, no, maybe so. Anybody, any suggestions? Okay. The
Yes.
answer- Yes, okay. Lawyers love to hear that, but the answer is not necessarily. A will is always a nice thing to have, but it's not necessary completely. If, for example, you have, if you can guarantee me that you are not going to die before your beneficiary, then you don't need a will, because you can do all of your planning by pay on death accounts, transfer on death accounts, joint accounts. So you really don't need a will if you can be pretty sure you're going to die first. And that sounds a little funny, but quite frankly, there are people who know that they are in extremis. They're going to die within 4 months, 6 months, whatever. All you have to do is make everything joint or with a pay on death account. And then you don't need a will. Good for you. You've avoided spending any money on a will. Now, if you are younger and you can't guarantee that you're going to survive, then you probably want to have a will. Because what happens if you don't have a will? Can anybody tell me where your money goes if you don't have a will? Anybody? It's funny, you're all muted, so it's hard to say.
Yeah.
Somebody unmute and
Isn't
answer.
it, doesn't it go into like an probate or something until it gets figured out?
Okay, if you don't have a will at all, probate is a term that says, yes, there is a will. By definition, probate is proving the will. It's called intestacy if you don't have a will. And very few people know this. I mean, I ask this question all the time. I never get the right answer from anybody. So this is standard stuff. So if you have assets without any named beneficiary and you don't have a will, then your estate falls in intestacy. And that just means, intestacy means without a will. Now, what happens if you don't have a will? Who gets your dough? Well, anybody have an idea who gets it? Mostly somebody says the state. And I always say, what? Why
Close-
would you leave it
close
to the
relatives.
state? What?
Close relatives.
Yeah, and the closer they are, the better it is. So for example, if you're married, it goes to your spouse and children. The first $50,000 goes to your spouse, and half of the balance goes to your spouse, and the other 50% goes to the children equally. If you're not married and you have children, it goes to the children. If you're not married, you have no children, it goes to your parents. If your parents are not alive, it goes to your brothers and sisters. And if brothers and sisters are not alive, it goes down the line. It takes a lot before nobody gets it and it goes to the state. It's called a sheeting to the state. And I will tell you, in my practice, virtually never have I seen it happen. All the way, by the way, all those unclaimed funds that on this resource list, a lot of those monies are from estates where the money, the court could not find the heirs. So the money goes to the state. But in New York State, that money is always available to you. So for example, before computers were ubiquitous, we did estates all the time. And we had no way of checking unclaimed funds the way we do now because we didn't have computers. So when our computers became common, I went back and looked at a lot of the estates I had done, and I put the names in. And there's one estate I'll never forget. I'll call it Smith, although I don't know, poor Smith family, they always get picked on Smith. Everything is Smith, Jones. I call it Anderson. Anderson's a very common name too. So the Anderson family, I went online, I put the name Rita Anderson in, and out popped 8 accounts. Well, most of these accounts are a few $100s. And so they had moved, the heirs had moved several times and they'd moved to California, and I tracked them down and I said, oh, by the way, Anderson family, I found these 8 accounts for you, and you should really collect them. We don't know how much they are, but you should collect them. And they were very happy and they collected them. They collected to the tune of $535,000. No kidding. A couple of years later, I checked again for the same family because I was pretty shocked. 3 more times I checked, and they came up with another 50,000, another 8,000, another 7,000. There's probably still money there. Legally, these banks and brokerage houses are supposed to turn the money over within 3 years, but these accounts had been lingering for a long time, and they don't want to change. They don't want to send them over to the state so easily, because if you keep money in your own account, you get the benefit of using that money for investment, a brokerage house, a bank account, a bank. Always check the unclaimed funds, and check every few years, and check for your family. You become Santa Claus. So I guess sometimes when I'm having some fun and have nothing to do, I go online for friends and I'll just check their names and I'll send them a note about it. I'm really kind of shocked at how few people actually tell me that they've collected the money. I think they must think I want a piece of the action, but I don't. I just think it's fun. Everybody has an avocation. That's sort of my avocation. I just check every so often. But now you know where you can check. So check. Not while I'm talking, though. Not while I'm talking. When we're finished. So let's go back to, do you need a will? So I've told you, if you know you're going to die and you have everything in joint account, you don't need a will. Let's say you have everything in joint account, but you have maybe $20,000 or $30,000 out there, and that's all there is, because your millions have already been allocated. So you have $30,000. Do you need a will for that $30,000? The answer is no. And you don't even need to probate a will that you might have. There is an affidavit called an SCPA 1310. The only thing I want you to remember really in this is that it exists. You don't need to know all the numbers. You can just go to the bank and say, bank, I've got my 1310 affidavit. You're holding $25,000 of my husband's money. He died 2 weeks ago, and I want that money. You have to wait about 15 or 30 days to get that, but you just go to the bank and get it with a 1-page affidavit. And if there are minor children, and if there are, let me stop that. So even if you're not a spouse, let's say you're a brother or a sister or a parent, you can do that also. I just did this last week because I get calls fairly frequently. There's only a very small account. It's about $20,000, $10,000. The bank tells me I have to go and get my will probated, my mother's will probated, or I have to get it administered. And I say, no, you don't. This 1310 affidavit does it. And so we prepare the 1310 affidavit. They take it to the bank, and the bank says, oh, I never heard of this before. I don't know anything about it. So then they have to call me up. I say, go to your legal department. They know about it, 1310 affidavit. Although just the other day, I actually had somebody from a major bank, head of the Trust and Estates Department, and I had given somewhat of a lecture on this, and he didn't know anything about this 1310 affidavit, which was kind of shocking to me. And he's going to use it. So if you have a small estate or a small amount of money outstanding, and you've already taken care of all your mother money with joint accounts or trust accounts, just do this 1310 affidavit. But let's say you have more than $30,000, but up to $50,000. You can do what's called a small estate administration. And you know what the filing fee for a small estate administration is? $1. $1. And you can do this yourself online. You just go to courts.state.ny.us, and you can fill the form out yourself, file it yourself, and it'll be $1. And that will collect up to $50,000. Now, who can collect that? Same people who could collect it earlier: the spouse, the children, the brothers, the sisters, depending upon whether or not you have any spouse or children. There's a hierarchy in the law as to who can collect this, but up to $50,000 can be collected. So in that case, you don't need a will either. because if your estate is under $50,000, your family can just do a small estate administration for $1 and no will is necessary. So bravo, you've saved a lot of money. You've saved the money that would go towards paying a lawyer to do a will. Now, the other thing is, there's what's called a family exemption that I would say 85% of attorneys don't know about it. I had a will challenge recently and I was able to get a client this additional $25,000 in addition to the will challenge, because the family exemption says the first $25,000 of any estate comes off the top and it goes to the spouse or minor children. Doesn't even come into the estate. Kind of crazy, isn't it? Nobody knows about this, but it's called the family exemption. So if you're a spouse and you're fighting with your stepchildren, you can get this extra $25,000 off the top, in addition to your $50,000 and your half, if there's no will. Obviously, if there's a will, that's a different story. But the first $25,000 still goes to the spouse. So now, if you have no will, let's talk about tax. Let me stop you. Let me ask if there are any questions on that.
Yeah, there are a couple. One
Sure.
is, what happens if without a will, more than one relative wants to be appointed administrator?
Okay, it depends upon the hierarchy. If it's, again, it's a spouse, always has first choice. Children, grandchildren, brothers, sisters, although parents are there, although parents don't often come into play because they're usually dead. Although I had people a few years ago and they were in their late 70s and I said, well, all your parents are dead. And no, none of them are dead. There were 4 sets of parents and they were all alive and the people were in their 70s, late 70s. I was shocked. So it's a hierarchy as to who collects. But let's say you have 2 sisters who are of equal, they're both sisters and they're the ones who can collect. They can be joint administrators, either or. They can be joint, they can be either or, but let's say they're fighting. So one sister will file a petition and then the other sister will file a counter petition and then the court will decide who gets it. And the court may say, wait a second, neither one of you can get it because you're fighting and I don't trust that you'll do the right thing. And the court can then appoint what's called a public administrator to handle the estate. Once you tell a client that the public administrator will charge between legal fees and public administrator fees, at least 11% of your estate, the kids generally will get along. The sisters generally get along because I say to them, really, you want to put 11%, 110,000 of your $1 million estate, you want to just give that away when you can do this, that money can be in your own hands. Money plays a very strong role in how people get along. It also plays a very strong role in how people don't get along. If you read The Ethicist yesterday in the New York Times, The Ethicist, the question was, one of my kids has a lot of money, one of my kids doesn't. Is it fair for me to give more to one kid than the other? And the ethicist said, yes, it's fair, which I agree with. But the ethicist also said you should have a family meeting to discuss this. Well, let me tell you something. I wrote to the ethicist last night. I said, no, do not do that. If you have 2 kids or 3 kids or 4 kids, one of them or 2 of them is always going to be better off financially than the others. One of them, 2 of them are always going to take care of you better than the others. So of course you want to give more to one than the other. But if you have that family meeting, oh my gosh, you are making it is a recipe for disaster because that family meeting will never, ever be forgotten. So the relationship that you have with your kids now, because they all think they're getting even Steven, that goes out the window. You had this ridiculous, stupid family meeting and said to Susie, well, Susie, your husband works at Goldman Sachs and makes $6 billion. And little Johnny, he's a musician. He doesn't make so much money. Well, your daughter felt you always favored Johnny anyway. And here's yet another example of your favoring Johnny. And I don't care that my husband makes $1 billion. That's irrelevant. This is your money and you should be giving me the money the same as you give to little Johnny. And It's never good. I've had many people come back to me after I tell them, don't do these family meetings. They never work out well. And I've had people coming back in my office crying their eyes out because they didn't listen. They did this family meeting and it did not end well. So I wrote to the ethicist last night, my first time, I think, writing to the New York Times. And I explained why it's not a good idea. And I'm going to see next Sunday whether or not the ethicist agrees with me, because I usually agree with the ethicist, but not in this case. He is a professor, and I think a very good professor, I think, philosophy, but he doesn't practice law, that's for sure. So so the question then becomes, you've decided I want to do a will. The will should be what you want. Your will does not have to be what your husband wants or your wife wants. You should do what you want, you should do what, and your husband should do what he wants. But there's a funny situation here because many people say, okay, I'm going to give everything to my husband, and when he dies, it'll go to the kids. Sounds good. Pretty standard. Well, wife dies, and husband remarries and marries a much younger woman. Of course, they always do, right, ladies? They always marry a younger woman, and that younger woman wants children. So now your estate is now going to be given not just to your kids, but to be shared with this witchy woman who's going to have these additional children. So you may not want, if you have a sizable estate, you may not want to give all your money to your spouse. You might want to protect some of it for your own kids to make sure that the next wife or the next kids don't get all of your money. Now, can you cut out a spouse from your will? The answer is yes. You can say, I'm not giving my husband any money at all. Well, that only works so far because your husband always, with the exception pretty much of whether if he's abandoned you, and I use husbands all the time because I'm a woman, so that's the way it works. So if your husband has not abandoned you, your husband gets, and if he hasn't killed you, by the way, you don't get it if you've killed your spouse. If you have not been abandoned, you have not died by nefarious means of your husband has a right to 1/3 of your estate. So while you can in your will cut out your husband is entitled to come into court and say, not so fast, ladies and gentlemen. I want my 1/3. I realize I'm not getting more than 1/3, but I want my 1/3. And your husband gets it. Now, I've had cases where we've actually had to defend against that, saying, wait a second, husband abandoned wife. He left 20 years ago and has been living with his chickadee in South Carolina. And so he doesn't get this money. And in fact, if he has abandoned the wife, he doesn't get it. Well, let's say he's not as bad as we think. He's left and he's living in South Carolina, but he still pays money to his wife every month out of guilt, whatever he pays her. That's not considered abandonment, and he gets his 1/3. Let's talk about taxes.
Okay, yeah, there's a question
Oh,
actually.
sure,
about
go ahead.
taxes. And one of the questions was whether all of this money is taxable as added income.
It's funny you should ask that question because that's what I was just going to go to.
So-
So right now, you have $11,700,000 to give away to anybody you want, federal tax free. So if you like my seminar a lot and you have 11,700 you want to give to me, go for it. So and by the way, let me not forget one thing. I'm not really expecting your $11,700,000, so don't worry about that. But it did occur to me, when you do the unclaimed funds, it might be a nice idea because you got this information from the library. 10%, let's say, of whatever you collect. Give some thought to giving it to the library who got you into the seminar. It might be, it's a nice thing, it's tax deductible, and it's a way of saying thanks to the library. But right now, $11,700,000 tax-free. And if you're a married couple, that is twice that. So that's $23 $23,400,000 tax free, federal tax-free. My opinion, it's crazy that this is so tax-free, but that's the way it is. Now, I don't think it's going to be that way forever, but it's the way it is right now. But New York State is different. New York State doesn't have this $11,700,000 tax-free. New York State is $5,930,000. Now, that's still a lot of money. But what New York State doesn't have, and the federal government does have, is a gift tax. We expect this to change this year, but what does that mean? Let's say, and there are a lot of people, there are 32 participants, so some of you are double, so we have at least 50 people on this screen right now. I will guarantee you that a bunch of those 50 people have this $11,700,000 to give. But when you die, if you give it to your spouse, that's tax-free too. So let's say you have $100 million and you give it all to your spouse, that's tax-free. It's the $11,700,000 is to anybody but your spouse, because everything you give to your spouse who's a US citizen is tax-free. If you're not married, you have $11,700,000 to give to anybody. New York State is this $5,930,000 right now as of January 1st, 2021. You can give that away, but if you know you are going to be dying in 4 years, because there's a clawback, you can give away in New York State as much as you want. You can give away $100 million and there's no gift tax. You'd have a federal tax, but there's no New York State gift tax. So there's something to be said right now, because if you want to give away money now, if you're of a certain age, now might be a good time to give away some money, because with no New York State gift tax, you're getting a free gift to somebody. Whereas in a few months, when the legislature has redone the gift tax exclusion, which is the plan right now, it is likely that the gift tax and the estate tax will be combined so that you will have one exemption of $5,930,000 plus anything going to a spouse. That is likely to be reduced. I don't see the state keeping this high $5,930,000 exemption right now. The important thing is for you to know that this, if your estate is under $5,930,000, completely tax-free right now, plus anything you give to your spouse. Now, this is a little technical, but I think you should know it. If you have an estate more than $5,930,000 and you have no spouse, the tax on that estate is very high. And it doesn't exempt the first $5,930,000. The estate tax kicks in at $0. So for anybody whose estate is over $5,930,000, well, let me make it 6 million because it's easy to say it. If your estate is over $6 million, you want to do some estate planning now to save taxes. And each state's tax varies. The federal government doesn't change. That's the way it is. But that's also going to be reduced. So if you want to do some gifting, now is probably a good time for those high asset people. But every state has a different tax schedule for estate taxes. And you really, if you're a Florida resident, for example, there's no estate tax. A lot of people, they say a lot of people move to Florida. I have a lot of high asset people and they're not going to Florida no matter what. But it is something to consider if you are going to die soon and you have a lot of assets, that maybe you do move into a no estate tax state to save on estate taxes. Ethically, I'm not comfortable with that, but legally you can do it. And that's my obligation, is to tell you what you can do legally. So are there any questions on the tax aspect? Because that's a little confusing. And I hope I explained it well enough to know that, for you to know that you're either tax exempt right now if you're under 5,930, or you are somebody who has to consider some tax planning.
So there is just one question.
Sure.
if, this is on the federal limit, if the 11.7 million is a lifetime exemption, why is there the need to annually report anything given away over 15,000?
Okay, because the 11 million, let me just say 12 million because it's easy. The 12 million is a lifetime exemption. If you give more than $15,000 a year, you have to report that that additional, let's say 100,000, because that comes off the $12 million. So if every year you give away, let's say $1 million to your son, $1 million a year, and at the end of your life, you've given away $15 million, and you have filed these annual tax returns as you do for anything over $15,000, then the government knows you've already used up your exemption, your lifetime exemption of $12 million. And not only that, you've gone above the $12 million. So you are going to pay estate taxes on that additional money above the $12 million. So you have to file a gift tax return every year so the government can keep track of it, so that if you go beyond your exemption, then the government can claw back some of that money.
Okay, and we just have one other question, which isn't about taxes, but about wills. And that is, if money is left to young grandchildren, do stipulations have to be stated in the will as to when the money would go to them?
Yeah, that is something I was getting to, both grandchildren and also supplemental needs trust. If the grandchildren are young, it's certainly a good idea to set this up in what I call a grandchild's trust. And generally, depending upon the size of the estate, the grandchildren can get it when they're 21, 25, 30, 35, 40. Most people don't take it past 40, and most people don't even take it that long. But yes, it is a very good thing, because when we have young grandchildren, we don't know what they're going to be like when they're 20, 30, 40 years of age. We really don't know. Are they going to be drug addicts? Are they going to marry the right person? By right, I mean a good person. Is it a drug addict who they've married? Have they become drug addicts? Have they been in jail a lot? Are they mentally disabled? Has schizophrenia taken over their lives? We don't know any of that. So we put in all wills 2 documents. If there are grandchildren or potential grandchildren, we put in a grandchild's trust. And then for the last number of years, I put in a whole paragraph, and it's a very long paragraph. And it says, if my beneficiary is disabled, then the money gets put into a trust. And why do we do this? Let's say our daughter, because I pick on sons a lot. Let's say our daughter, unfortunately, she's 21, schizophrenia, she's become bipolar, and the medicine is not doing well for her, and she's on Medicaid. If you give that money to her directly, she gets thrown off Medicaid, and the money just goes into her hands at age 18 years of age, unless you provide otherwise. So you want to make a provision in your will that says, if any of these beneficiaries, that includes my spouse, becomes disabled, the money doesn't go to my spouse directly. I'm going to put it into a trust so that the money is available to use for my spouse's or my child's or my grandchild's care. But that does not allow that person to be thrown off Medicaid. It's for extras. So you have a double whammy here. We have the grandchild's trust, who's very young, and if they grow up and everything is great, then they'll get this money when they're 25, 30, 35, however. But even if we find out, let's say it's 25 and they have a horrible accident, they're paraplegic, if we give all the money to the grandchildren as we expected we would have, well, that money is just going to pay for nursing home care or care that Medicaid would otherwise pay for. So we have this catch-all trust that will allow us to protect those assets, so the money doesn't all get frittered is the wrong word, get used up when it didn't need to be used up. And that's something you should look in all of your wills. We've been doing this for the last several years. I think a lot of attorneys don't do it. It's a mistake. And you really want to make sure, go call your attorney up again and say, well, wait a second, I just took the seminar. I should have a provision in here. What if one of these beneficiaries gets disabled? Make sure that gets put in either as a new will or as a codicil, because that could be very important. it's especially important because we're all of a certain age. Well, no, there are some young people on here, but we're all of a certain, most of us are a certain age. And one of us, a spouse, may wind up in a nursing home. And if I die, and my spouse is in a nursing home already, and I've given him all my estate or a good part of my estate, then that nursing home is going to get it all unless we have this other power of attorney with the statutory gifts rider. So there are always ways to protect assets if you've done the right planning. And that's key to getting this so that all the money doesn't go out the window. But yes, grandchildren should be protected. And this extra paragraph should be put in to make sure that the spouse or beneficiary, if that person becomes disabled, that money doesn't go to them directly. And that brings me to what's called, is there any other question?
There's one more question.
Sure, sure.
Nancy Kaplan has a question.
Sure.
130,000. Is that per person or is that a couple?
I didn't hear what you just said.
The 5,930,000
Per person. Per
Okay.
person, per person. And there's also a thing called portability. And let me just briefly tell you that because this is a little bit, let's say you really have a very large estate and your wife does not have a very large estate and she dies first. You can use her exemption and have it carried over to you with what's called portability. It's just a check mark on the box. In fact, it's not even a check mark, it's automatic now. And you can use, when you die, you can essentially double up by using her exemption on top of your exemption. It applies to so few people, but it will apply to somebody on this seminar. And just know it exists. Talk to your attorney. I'm just going to move out of the sun because sun is coming in here. Just know that you can double up. New York State does not have portability, so you cannot use your spouse's exemption. It's yours and yours alone. Now, let's talk about a supplemental needs trust. Unfortunately, a lot of people do have grandchildren with needs, special needs, and I choose grandchildren, but it could be a brother or sister. There's a thing called the supplemental needs trust. That disabled person generally is on Medicaid. And if you in your will, you give money to that person outright, then that person, one, gets thrown off Medicaid, if it's enough, and that money has to be used for that person's care forever and ever until it's dissipated. But if you set up what's called a supplemental needs trust in your will, it says, look, if anybody here is disabled, I want this money going into the supplemental needs trust. That becomes part of that paragraph that I talked to you about, that single space paragraph that we've thrown in the last few years. But if you put it into a testamentary trust, it could be overseen by the courts. So what we're doing now and have been for a while is if you have somebody who is disabled, it is better to set up a supplemental needs trust in advance of your dying. You don't have to fund it with more than $1. You need even $1, you don't need to do it. But it takes it out of the umbrella of the court's oversight. So if you have a grandchild who is disabled or a child, then set up a supplemental needs trust now. It's a 5-page document. It's not complicated. And then when you die, you haven't funded it during your lifetime. In your will, you can say, and I give $100,000 to the supplemental needs trust that was established for my grandchild on June 1st, 2019. And the money rolls over into that trust and gets used under the trust terms. It's a very nice way of doing it because it allows grandparents, and usually is a grandparent doing this, it allows grandparents not to leave out that disabled child, but yet not to create problems with getting that grandchild thrown off Medicaid. So many trusts, so many clients come in with old wills, and they have let's say they have a disabled son and an able daughter, and they've given in their prior will everything to their daughter because their daughter will take care of their son. I know it. I know it. And then I say to you, I say to the client, I say, and I believe that daughter will help. But let's say that daughter now dies. Do you really think your son-in-law is going to give your brother, or rather your son, the money? Of course not. Because that disabled brother, or son in this case, of course, has been a thorn on their side because it's not easy taking care of a disabled child. So the mother thinks the daughter will do it, and the daughter is honorable and will do it, but the husband doesn't have that same connection to your son as your daughter has. So the thing to do is not to give everything to your daughter. Give something to your son through a supplemental needs trust, because at least that's protected, and the son-in-law, if your daughter dies, won't get it all. But let's say the son-in-law isn't even in the picture. Let's say your daughter dies and she has minor children. The court will never invade that trust for minor children for your disabled son. So if you have a disabled son or grandchild or brother or sister or anybody who you want to protect, set up a supplemental needs trust. It's not a big deal to do it. It will make you feel better because you will have taken care of that child, that person for sure. And the trustee can be your other child. It could be a niece, a nephew. It could be anybody who you trust. It could be, if it's a large one, it could be a bank. But you probably will be more comfortable not ignoring that child who is disabled. So another question that comes up is adopted children, do they get treated the same way? Yes, they do. They should. And so should grandchildren, adopted grandchildren. And that's not a change in the law, but that's the right thing in the law, and they do get treated the same way. Now, occasionally I have a situation where a grandchild is in utero, which means not born yet. So in the wills, I put a provision in that the grandchildren get everything, and any grandchildren born between the time the will is signed and the time I die, all grandchildren are treated equally. Now, let's say you're younger and you don't have grandchildren right now, or your kids don't have children. Have your attorney put in a grandchild's trust anyway. Why not? Why have to bother doing a grandchild's trust and spend more money? Just say, oh, by the way, I'd like a grandchild's trust in here. And the attorney say, well, you don't have grandchildren, or your kids aren't married yet. Well, yeah, but they will be, and I will. And why not just take care of it right now? So put that in, get a grandchild's trust in, and get a supplemental needs trust, either in the will or outside of the will for anybody who's disabled. This we touched upon a little bit ago. Should you treat your kids equally? The answer is, if you can, yes, it is certainly better. They will get along better. But if there is disparate assets, then by all means, give one more than the other. But if you can, say in your will, I give everything 50-50 or 25-25, one-third to all of my kids, and then set up a separate account outside the will. Now, it may be that the kid who isn't benefiting by that outside account learns about it, but at least the will shows that you love them equally. And that's really important, because kids, the baggage that people carry with them, God, it goes forever. I had a woman, and this, I'm not even exaggerating, she was 92 years of age and she was cutting out her sister. Why? Because when she was 7 years old, her sister took her doll, and she has never forgotten that. So she cut her sister out, and she was competent. I mean, you know, she was competent. I said, Mrs. Smith, you really want to do that? Yes, she was really still angry. But with kids, let's say you have 3 kids, and I know parents always say, I love them equally. Well, that's not the reality. There's always one kid who gets favored somehow. And the other kids generally know about it. And if it's not too much of a favor, it's okay. But if in the will you give that kid more, oh my gosh, the other two or the other one or the other six are never going to forgive that child. And that relationship will be broken forever and ever. So if you can put in the will, I give everything equally, then set up a separate account outside the will that this child who needs more will get. And if it's one of the children, for example, it's very often the single child, the person who's not married, who winds up doing more for the mother or the father. It's not fair and resented, by the way, by the single child, because she's always the one who has to do everything. But it's reasonable to say, wait a second, Mary, you've done so much for me. I want to do something extra for you. Well, if Mary is very well fixed financially, it's not that important. It's not important at all. But if she's not, set up the separate account for the child who takes you to the doctor, who calls you every day. And if the and don't give it equally for the kid who lives in Idaho, never comes to visit, never calls, even on WhatsApp or Zoom, never bothers to speak to you, but thinks he's entitled to his share because after all, he's one of your children. Do the separate account. It's just a better way of doing it, and it will be less painful. Now, when does the will get read? On TV, the will has this great big meeting. Everybody meets in the room and everybody goes, yay, or oh no, I'm going to kill you. Mom shouldn't have done that. It never gets done that way. After you die, a few days later, the will is found or the lawyer is called and we send you over copies of the wills right away. And that's the way it gets read. I have had one official sitting down will signing. It was okay because everybody got what they were entitled to, but it's just not the way it's done. Now, there's one point I was just about to make and I just lost it. I hope it comes back. So let me see if there are any more questions on this. Oh, a trust versus a will. Should you do a trust? Oh, two more things. Well, many more things. Okay. Should you make your attorney the executor? No, no, no. There's no reason for your attorney to be the executor unless you really have nobody else. And sometimes that's the case. And then if your attorney is trustworthy, it's a good choice. But I have had many people come to me, and when I go to say, who would you like to be the executor? They say, you. I said, well, why are you picking me? You have grown children. Well, the attorneys always made themselves the executor. No, no, no. If you have an attorney who's put himself in the will, and it's usually a himself, I will tell you, change your attorney, because there's no reason if you have bona fide good children, trustworthy children who get along pretty well, don't make your attorney the executor. Now, I had one time where I went through the whole spiel with the woman. She wanted me to be the executor. I said, it doesn't make sense. You have two grown children. They're good kids. They hate each other. They will never get along. The kids came to me. We, looked at the will. They were not happy because the mother had made me the executor, against my advice, by the way. A few weeks later, the husband who survived came to me, and because he didn't want to be the executor, and said to me, my wife was right. They hate each other. They can never get along. And at least you'll be a good intermediary. But for the most part, I discourage people from making me or any attorney the executor because we get a fee. And that fee can be quite substantial. On $1 million estate, that's a $34,000 fee commission plus legal fees. It's better to keep it in the family. Why give it to me or anybody like me unless there's a real need? There are some people who don't have anybody else. And then it's reasonable to make your attorney or your executor or your friend, but don't make your attorney an NSA. If you have an attorney who makes himself the executor, say, gee, you know what? I have to go out and put money in the meter and then just keep running. Just get away from that attorney. Question is, what about a trust versus a will? Because that comes up a lot. In New York State, probate is very easy. I know there's a book, How to Avoid Probate, and that has been the bane of our existence for decades now. But probate is not expensive. It doesn't have to be expensive and is quite easy. So I will tell you, unless there's a reason to do a trust, just go through probate. And then if you change your mind, you can change your wills easily through codicils or even just redoing the will. If you do a trust, and some people do, a lot of attorneys push trusts, and I'll tell you why. They will justify it a lot of ways, but a lot of the reason is because we charge more for trusts than for wills, probably 2 to 3 times as much. But they're really not necessary because probate can be very fast if you have close relatives. If you don't have close relatives, if you have distant third cousins, second cousins, down the line, it's probably a good idea to do a trust, because if you go through probate, you have to find those beneficiaries, which can be time consuming and expensive. But close relatives, sisters, brothers, aunts, uncles, cousins, first cousins, not too much further than that, spouses, children, just do a will. It's easier, it's less expensive. It's just, in my opinion, a smarter thing to do. A lot of lawyers will say yes, but then at death, the trust goes faster. I can tell you that in every case where somebody has done a trust, one of two things happen. Either they never fund the trust because they don't really understand how to fund the trust, or there's always something that falls outside of the trust and you have to go through probate or administration anyway. That's the reality. So, and for those attorneys who may be listening, yes, maybe there's a reason for do the trust, and maybe you're not one of those attorneys who are doing it for the money. I'm not talking about you. Okay, any other questions?
Yes, there are.
Sure.
Actually, I have a question, and that is about beneficiary accounts as opposed to a will. I mean,
Yeah, I like them. I like them because if you have one child, as I do, a beneficiary account is great because it goes to her directly. She just takes a death certificate to the bank and the money is given to her directly. But if you have more than one child, it becomes a little more dicey, because what if the child, what if the child dies? One child dies. So you have an account for Mary for $100,000, an account for Johnny for $100,000, and you have a will saying I give everything equally. Mary dies. Where does her $100,000 go? It goes back into the estate where you've now said half and half. So Johnny gets his $100,000 from the bank, plus he now gets the half from the will. So Johnny winds up with a lot more money than your daughter did or your daughter's kids do. So you have to be a little bit thoughtful about how to do this. If you can do it where your account is set up, I give everything to my daughter, and in the event she dies, it goes to her children. That's okay, but a little problem there, because that means those kids would get it when they're 18 years of age. And if there's a disability in play, then that money could throw that child off Medicaid. So these in trust for accounts or paid on death or transfer on death accounts, I think are terrific. If you have one child, or if you're about to die and you're pretty sure you're not going to outlive any of the children, they're great, but they can really skew your estate plan by a child dying before you. And statistically, 1 out of 3 to 1 out of 4 children dies before a parent. So you always have to prepare for the what if. So the answer is yes, they're great, but you have to make sure your estate plan says something about that. So what I do is I have a paragraph in my will that says, if any account passes outside of the will in trust for, then that child's children or whatever inherit that child's share, and it gets distributed as the will goes. So it's always going to be even Steven if that's the way I've chosen it to be. Was that clear? Because I know it's a little bit confusing, and I want to make sure that was clear.
yeah, I think so.
Okay.
And so we have another question about trusts. What are compelling reasons for revocable trust versus will? Which is
sure. The revocable trust, the benefit of the revocable trust is that when you die, the distributions can be fairly quick. They rarely are, but they can be fairly quick because the trustee of the revocable trust can make those distributions quickly. I'm involved right now in a challenge where there was a revocable trust there was an estate, an estate, and the revocable trust, and I just came on board, has still not been distributed, and it's 3 years later. So the advantage of the revocable trust primarily is supposedly it's a faster administration of the estate. And if there are distant relatives, you don't have to look for those distant relatives because the trust controls. With a will, if there are distant relatives who would inherit, a long lost cousin, for example, you have to track down those long lost cousins, and that takes time and money. That's the reason for revocable trusts. By the way, revocable trusts become irrevocable on death. And that's because on death, you can't change your trust because you're dead. So that's the advantage. I like the disadvantage, it's more expensive when you set it up. It's also more time consuming because you have to transfer all your assets over to the trust. And I have literally never seen anybody ever do all of their assets put into the trust. So I'm not a big proponent of trust, but there are many attorneys who are. And I think probably more lately for some reason, I'm not sure why, but I know about 10 years ago, I went to a trust and estate seminar like this, but given to very high-powered T&E lawyers, and they all said, no, don't do trusts. And that's been my mantra before and since that. I just don't see the real need. Occasionally people insist on it. I'm fine with it, but I do try and dissuade them because financially it's better for me because I can charge more, but I just don't see the need for it.
We have a couple of more questions. One is, do you know about a post? And I don't know what that is.
Most. Yeah, a mulch is it's a pink piece of paper, and it gets put on the door, and it says essentially, do not resuscitate this person. A doctor has to sign it, and when EMS comes in and finds you're in a very bad situation, they will not resuscitate you if you have this mulch on your door, this pink piece of paper. I had something recently where they had the mulch and they put it in a closet. I said to them, I said, that's not going to work. But they didn't like that it was a colored piece of paper. This pink, they didn't like it, didn't go with the decor. So they put it in a closet, and it was useless because the EMS are told to come in, look for the mulch, no mulch, they resuscitate the person.
Okay, and then we have a question about, where is it? Why does a person who dies within 30 days of the benefactor not inherit?
No, that's not true. It's actually 96 hours. And it's not that you don't inherit. Let's take what some people do is they put in their will that the beneficiary has to survive by 30 days. And that's okay. Because let's say you're in a car accident, you and your spouse are in a car accident, or you and your brother, or whoever it is. And my will says I give everything to my husband. Now, my husband has children from a prior marriage. So I die, I give everything to him, and he dies 10 days later. His kids get everything, whereas I might have wanted to give my family some of that money if we died simultaneously. So there's very often a survival clause of 30 days. You have to survive by 30 days. And 30 days is reasonable. But the law now was changed a few years ago, and it says that in order to inherit, you have to survive by 96 hours. That can be overridden by your 30-day requirement. But let's say, and this is again for these common accidents, let's say my husband and I are in an accident, I die today, he dies tomorrow, I've given him everything. So everything goes to his estate and nothing goes to my estate. And that's not what most people would want. You'd want to divide your estate the way you want, because let's say you have an equal amount of money, 2 people. And if my husband dies first, I want my family to get it. If I die first, he wants his family to get it. But if everything goes from me to him, then his family gets it without my family getting any of it. And that's not what really people want. So the court made this artificial 96-hour rule. I think it's too little. So in my wills, I very often have a survival clause, sometimes 30 days, sometimes 15 days. It's really whatever the client wants. But there's no 30-day rule in New York State. There might be in other states, but there's no 30-day rule in New York State unless you put it in your will yourself.
And there's just one other question, and it might need clarification. Mary Nellen asks, don't you need a trust if there is property involved? And
Property meaning real estate?
I'm not sure.
Commercial property. If one of the parents owned a business built, like my father had a dental office that was put into a trust, and it got sold years after he died, and that trust fund went to us after a period of time. So I thought that was why we had to have a trust, because of the commercial property.
No, that doesn't require it at all. No.
Okay.
It'd be odd to have a dental practice in a trust.
No, practice wasn't in the trust, the property was.
Oh, the real estate.
The building, right.
Oh,
right,
okay.
right, right.
Yeah, what generally you would not put it in a trust. What you'd put it in is an LLC,
Oh.
limited liability company, because what you want to do is to ensure that if anybody gets hurt on that property, that they can't go after your assets. They can only go after the property.
Oh.
Most commercial properties are not held in individual names. I did one recently. It was a $20 million property we sold, and it was in individual names. It was an apartment building, and they had this in their individual names. And I said to them, I said, if there's a fire, you're all getting sued for not only the $20 million value of the building, but everything else that you own. So we were selling the building, so we didn't do anything, but very rarely is commercial property, well, I shouldn't say very rarely, because I can't know about every property in the world, but most people who have commercial property put into an LLC to protect it against any real significant liability.
That makes a lot more sense. Great, thank you.
You're welcome. Anybody else?
I don't see any more questions.
All right. Well, it's been a pleasure.
Thank
Okay,
you so
well-
much.
Yes, thank
You're
you very much. And I will send out those documents to everybody, as well as a link to the recording. And I've had some people who left, had to leave early, who thanked you for a very good presentation and are glad it's recorded, because they will want to look at it again.
It's my pleasure. I enjoyed it. Thank you very much. Good
That was
night.
great.
Thank you all.
Thank you.
Bye.
Thank you so much.
You're welcome.